Hi, this is CJ Holmes again, founder of Homeowners for Justice, and your host today for Weekdays Live, bringing to you the latest and greatest in our fight against fraudulent foreclosures. Today, first off, happy Valentine's Day to everybody. Everybody, we wish you the very, very best. So, what we're going to see today are some really fascinating chips. I'm telling you, every day something is going on in this foreclosure battle, and we as owners and activists must do everything we can to shift and sway public opinion to the real fraudsters and the real deadbeats, the banks. It's not the owners, it's all about the banks. So we're going to review real quickly stuff in the news. The banks are supposed to review the foreclosure. Oh yes, let's go trust the felons to figure out what they've done wrong. There's smart. And then I've got a question for you. I'll probably try to put a little survey together to get your feedback on this one about the foreclosure asset class. And then we have a special guest today. He wrote the book on how to file a notary complaint. He's done it himself. He's in court. He'll explain all that kind of information. I've got some really tough questions for him. Rob Rhodes, we welcome you to the show here in just a few minutes. And before that, before we even get into the news, one of my jobs I view, because I'm a real estate broker and I do real estate and I understand how these things actually do work. And I want to address a rumor. It is simply that you might have seen it. This is the second or third time I've seen this. And so when I'm starting to see this repeatedly, then I know it's out there, it's going around, and everybody that sees this, it will be helpful if you really understand how I look at these rumors, because it has to do with real estate and real estate transactions and short sales and how they're defrauding the government and stuff like that. I believe it's a straight rumor intended to sway the public against homeowners. Here's the quick summary. It came to me via Skype. This is what I'm just showing right now. I've already seen it before by email. And this is what somebody wrote. Michael says, as a realtor for the past 28 years, I thought I'd seen or heard it all. Until now, I was showing homes in Pontiac, Michigan. One afternoon recently, and she showed up at a home at about 4 p.m., and they woke the homeowner. She let us in and then proceeded to tell my buyers and I that she had already entered into a contract to sell the home on a short sale, and explained that's where the bank, the lender, servicer actually, makes a decision to take less money than what is owed because the value of the house has fallen. And so this article claims that this person, this owner, is telling this realtor that she and her sister, who lived in the area, were buying each other's homes via the short sale process. And this realtor said, well, I thought relatives couldn't be involved. And she says, oh, we have different last names, nobody knows. She went on to tell him, this is the claim, that they each owed over $100,000. They're in the process of buying each other's homes for $10,000 or $15,000 cash. To top it off, they were each receiving $3,000 in government-provided relocation assistance. That's called HAFA, H-A-F-A. Everything seems to be starting with H, harp. Anyway, my buyers and I, this is now the agent speaking, the person that claims that he's a realtor. My buyers and I were amazed that she was outright admitting to fraud, and yet she continued, told us the best part of the scheme is because they're currently not working. They're both receiving Section 8, and so each other is going to be renting each other's homes. And so what's really fabulous is that now they're saying Obama is going to give each of us $800 a month to pay the rent. And then it claims that she picks up a picture of Obama and does a little dance around the house, saying, oh, thank you, Obama. So here's the bottom line. This is how the story goes. Both of these scammers got at least $80,000 in debt forgiven, $3,000 in cash for relocation, and now they're going to get $1,600 a month in rent, perhaps forever. And then he goes on to, if you will, continue to badmouth these freeloader deadbeats by saying, oh, they're probably, I wouldn't doubt, they're getting food stamps and other programs and they're staying in each other's homes. You know, this is horrible, horrible, horrible. The implication, of course, being that everybody in this boat is doing this. And of course, she had a new SUV, 3 flat screen TVs, and a computer setup. Now, this is what I've experienced, and I'm not in Pontiac, Michigan. I'm in California. So our home sales and prices are at a much higher price point. When I looked at this just this morning, I went to Zillow, Pontiac, Michigan, and generally speaking, the houses are selling at $20,000, $30,000. So $10,000 to $15,000 in cash is a pretty low number, even in Pontiac, Michigan. Now, of course, we don't know where it is and that kind of thing, but let me point out to you the things that I think are really troubling and puzzling to me as a broker and as a realtor. If this is true, and he's a realtor, he knows they're committing fraud, or it sounds as if they are, because they walk in and it's a short sale. Then it sounds at the end as if it's already completed. And it's as if the bank has agreed to those prices. So it sounds so much to me like somebody that doesn't know really how it works is writing this stuff up. The other thing is, as soon as he finds out, he has an obligation to tell. He has an obligation to tell the agent he knows this, because that agent is now involved, both agents in the short sale, both short sales, if they're both selling short, is it the same agent? That agent or both agents are now liable. They will be sanctioned, lose their licenses. Both brokers of those agents would be sanctioned and lose their license, be sued, could possibly lose a license by defrauding the government. So you've got potentially 2 sales, 2 short sales. So you have 2 agents, 2 brokers. Then the buyers themselves, the 2 women, are liable for fraud. So he walks in, nowhere did he ever say, this is what I would have said. If I had written this, I would have said, oh my goodness, I walked in, these people are fraud, so this is what I did. I notified both agents. I notified both brokers. I immediately got on the phone and called the Department of Real Estate and complained verbally about these, filled out the complaint forms about them, and I called the Association of Realtors. If either of those other 2 agents or 2 brokers were realtors, I would have complained to the realtor agent Department of the Association of Realtors, because they would start an investigation, and I would have contacted both of those banks. You can find the banks. You got the contacted Chase, whomever. The fact is, I would have come in back to my office. I would have looked up the tax data. I would have found out who that lender is. I would have called that lender's CEO office on the phone and said, hey, you know what's happening over here? And I would know the addresses. I would give them both addresses. I would turn these people in. Now, nowhere does he ever talk or say anything about that. And I'm telling you this, in all of the people that I have dealt with, and that's hundreds of people losing their homes to short sales, either they want to sell short because they just simply can't make the payments and they're accepting that, or they're fighting the short sale. I have never in my life seen anyone pick up a picture of Obama and dance around. That sounds so fake to me when you're actually dealing with people that are losing their homes. The fact of the matter is, both of those women, if there's any truth whatsoever to this, and I doubt it, frankly, both of those women are going to have dings on their credit. There are going to be other ramifications to this. On their taxes, they're going to have taxes on phantom gain of that $80,000. They never address that. I swear, whoever wrote this is just writing fiction. So when you see this kind of stuff, please bring it to my attention so we can live stream this out. So people, others, everyone can understand this is crap. I swear to you. And I challenge Michael, some realtor in Michigan, to tell me, I challenge him, tell me the addresses and tell me your last name, because then I will turn these people in. I'm a realtor. Every realtor in the country has taken an oath of ethics that we're going to stand up against this kind of information. So everybody that reads this on Skype, everybody that gets this in the email, every agent, every licensee, every realtor should be screaming about this, saying, what kind of a guy is this? All he's doing, and when you look at what this story is doing, all it is trying to do is shift public opinion away from homeowners and away from the fraud. It's this one magic hand that's saying, oh, look how bad it is, while this other hand over here is taking the homes fraudulently. Word to the wise. Let me know. I'll be happy to tell you the answers. This is, I swear to you, I bet you it's fake. And I challenge Michael and anybody else, if it's not fake, prove it. Give me those addresses. Watch me do this. Okay, quickly now, an update of what is going on in the news. As you would expect, the first week in January, the OCC caved in and said, oh, we're going to give up independent foreclosure review. We just can't do it, mainly because the banks are paying third-party investigators billions of dollars to not find anything. My summary, my quick and efficient, that's my official summary, because whistleblowers have already said, we found this stuff. We went to the banks. They said, oh, we're going to narrow the rules. We can't. That doesn't count. That doesn't count. That doesn't count. Well, when nothing counts, you're not going to find anything. So now this is the OCC's solution. Now on my website, I have the email for the OCC. So I'm going to say, it just occurred to me right this minute, let's all email the OCC and say, what, are you out of your minds? They're going to have the banks do the review. So they're now saying that the banks themselves, fraudsters, the foxes in the hen house. Okay, let's have the foxes figure out, ooh, should I have killed that hen or not? And if I did, ooh, how much should it cost me? And the OCC is going to, regulators say they will check the work. I'm sorry, this just sounds like grade school. Okay, you do your homework and I will check it. I'll know if you lied or not. Are you kidding me? For one thing, here's a suggestion. I'll check their work. Let me go check their work. I'll do it for free. I'll go over there and I'll say to the OCC, I'm here. I'll do it completely volunteer and for free. I want to see all the banks' work. You show me all their work. You trust me. Trust me. I'll find out that fraud and what they're hiding and cheating and lying about. So that is, you got to read the article. They call it a latest twist in the review of more than 4 million foreclosures. You mark my words, 4 million homeowners are going to be really, really upset when they discover all their foreclosures were based on fraudulent documents. Okay, or forged at least. As we'll hear today from our guest, forgery is easier to prove than fraud, and that's true. Now, here's another link I want to share with you, and thank you again, everybody, for sending me links. This is the disparate impact in fair housing, 7 cases. I just want to quickly summarize. The point is that, and I want you to read the article, but it talks about these 7 cases. So here's one, US v. Countrywide. And of course, the DOJ, this is the federal DOJ, reached a $335 million settlement. And of course, I want you to notice, Countrywide has not admitted to any discriminatory practice. No. We won't admit. We'll pay a tax. Don't think of these as fines. Think of these as taxes on fraud, because they're paying $335 million. But now you'll see that I think somewhere in here they talk about doing $1 trillion worth of loans. So this is like a 0.0001%. I mean, it's like nothing. This is nothing. This is not even a slap on the wrist. This is just a modest tax on fraud. And that's how we have to start thinking about these penalties. A true penalty is, okay, we're going to take all the revenues from a whole year, like that's what they're doing with the SEC, $1 billion. Well, the SEC says that's more than we make in a year. Yeah, okay, now that's a serious penalty. That's not a tax anymore. Now we're getting into, cranking out true money. And this is what they've done. Wells Fargo's 175 million denies any wrongdoing. Here's one against Morgan Stanley, allegedly knowing borrowers, no wrongdoing. They're going to get some kind of penalty in March. Trust me, it's going to not be anything close to the money that was made. SunTrust Mortgage, they settled in May for 21 million, denied wrongdoing. No, no, no. And this is what's so infuriating and wrong. Even if they took all of that income, unless they put these people either out of business or criminally charge them, they're going to do it again. This is just a little tax on the profits. And trust me, their internal actuarials, they are saying, okay, let's see, we made X and we had to pay X and it turned out to be about 4%. Bingo. Okay, so now we're going to double our fraud this next year, and we already know in advance, what it's going to cost us. They'll charge us, they'll file a lawsuit, we'll settle, it'll cost us 4%. Bing, bam, bong on the people. We're getting bonged, and I want you to know that. Here's another quick article. I don't want to take much more time. I'm sorry. I tend to go on, and I know that. And so the single biggest threat to the Bank of America. Now listen to what they say is the single biggest threat. First, and this is a fascinating article. You've got to look at it. But they're saying, they said if B of A faced death by supernova in the financial crisis, that's in '08. In the years since, it's been battling death by 1,000 cuts. And so they're talking about the zillions of lawsuits. Here's a little chart about how much they've paid. This is just B of A. The red stuff is what they might have liability on the books in these lawsuits. But I wanted to point this out. It's like these things hit me. The trickiest bucket of all, the only bucket remaining then, is the one related to countrywide sale of mortgage-backed securities to institutional investors. Okay, nowhere in here did they ever talk about the criminal liability that they face and the RICO conspiracy and to commit fraud based on all of the forged documents. So what we are doing, we're building files of forged documents, and we're starting to feed them into the Department of Justice and our district attorneys. And these guys are actually looking at going, I might have a leg to stand on here. So these articles don't know what we're doing, obviously. And it is not the trickiest bucket, nor is it the biggest one. The biggest and trickiest bucket is how these CEOs are going to get their feet out of the quicksand of criminal liability when we bring charges against them personally. And that's our goal. Okay, billionaire hedge funds chasing Blackstone. I brought this before. I've been talking about this for over a year. This is the whole point. They're not listing the foreclosures. They're keeping them. They're still foreclosing. But anyway, they're going to keep them. They're going to sell them to the hedge funds. They make big bucks. The banks are behind this. And Pritzker, who has got billions of dollars now, they sold TransUnion last year. They own TransUnion Credit. Big supporter of Obama. I call it the power behind the throne. It's the big money. And no doubt one of the major reasons that Obama does and says what he does. But nevertheless, this is the point. There's another article, you can read about it, but this is what I want feedback on. Because someone sent me, this is really cool, they sent me Barclay's internal analysis. It's a birth of an asset class. They are writing, this is REO, stands for real estate owned, and that is a foreclosure. A vacant foreclosure is REO. And so this is a single page overview of the single family rental taking these vacant foreclosures, buying them real cheap from the banks in bulk, 1,000 homes at a time. This is totally different from mom and pop investors or even mom and pops that own 20 or 30 homes. They're not market movers. These are potential market movers. 1,000 homes at a whack in one county, they can shift the rental market negatively for the people, positively for the assets owners. So this is an overview, and my question to you is, and I've already written the email, should I send it or not? The email goes like this. Hey, just thought I'd let you know. These foreclosures that you are touting as a cool investment class, they were generated by fake and fraudulent documents. So when the owners start to clamor for restitution against fraud and their homes back, your investors might think they got bit in the butt. Now, the question is, should I send that? It's a summary. I didn't say it quite like that. But the answer is, how can, my motivation is, how can we stop them? How can we stop the banks, stop this game in action where they say, whoa, what are you talking about? What are you talking about? You mean we're going to be buying stolen property? You mean we're going to maybe have them taken back from via court judgment because these banks fraudulently foreclosed and the owners are going to get the houses back? What are you talking about? And my thought is, maybe we ought to sow a little doubt. Let me know what you think. Should we tip our hand? Does it matter? Or should we sow doubt? Tell me. What do you think? Because I'm right on the fence. So without further ado, I'd like to bring on board here our guest for today. Hi, Rob. This is CJ.
Hey.
Thanks for joining us today. Can you tell us a little bit about yourself, your book, and your experiences? And then we'll just be asking you some questions.
Yeah, my name's Rob. I live in Southern California, down in Chino. I've been involved in the real estate industry for, over 25 years. Have had several companies, several businesses, and have developed different types of investments. And then I purchased 3 homes. And one is an investment, one my office is, and obviously my personal residence. And then what I do is, like a lot of people in the real estate industry, times got tough and went into foreclosure and started actually studying as far as what was I doing. Exactly. And now when I figured it out, it was like, are you kidding me?
Yes.
And then I understand you had a gentleman named John Stewart on yesterday, and I started listening to John, and he kind of steered me in the right direction. And while I was listening to John, he kept talking about the same thing over and over as far as filing a notary complaint. And what you have to realize, notary complaint will slow a foreclosure down sometimes because Recon Trust doesn't really care. They just keep plowing ahead like a steamroller. But I got to the point that he kept saying the same thing over and over. And so I wrote a book on I wrote a guide on how to file a notary complaint. It's good throughout the country. And it's at notarycomplaint.com. It's just right there. You can go get the book. You can download it. And that the notary that's in there, it's in that guide, is the notary that's on my house. So it is a work that is in actuality, from the standpoint of
Robert,
that's the notary complaint that I filed with the California Secretary of State in April of 2011. I did actually finally, February 1st, the Notaries Commission did get revoked. So it took 22 months. So it's not exactly something that, it's not exactly something you can, get done right away. You have to remember, you're dealing with the government entity, and so they're not going to be in a hurry sometimes, especially to take away a commission from somebody.
Now,
they're going to want to investigate it, and in this particular case, it took 22 months for me to answer.
Now, John, let me ask you a couple of questions here that occurred to me right off. First off, you made the statement that Recon Trust doesn't really care about notary complaints; they just plow right ahead. So that didn't help you postpone any auction dates, or it did help you?
All properties are with Quality Loan Service out of San Diego.
Oh, okay.
And what I can tell you is when I put the notary complaint together, like the one I have written in the guide.
Yes.
Excuse me, something in my throat here. What it did was, I would get the sale date, and let's say the sale date was March 1st. What I would do is right around the February the 15th, we'll say it's tomorrow, I would fax them a copy of the notary complaint with a cover letter stating, hey, you might want to think about this, that, I filed a notary complaint with the California Secretary of
Okay, so you did get postponements because of this by just continuing to fax shortly before the sale date the same notary complaint to your foreclosure trustee is QLS, Quality Loan Service.
Correct.
Okay.
I mean, what you have to realize is it's a way to slow the foreclosure. You know, it won't really stop it, but it'll slow it.
Right. It's what I call a delay and stay tactic. And the only thing that we can do sometimes is to just delay to try to stay in the home longer while other solutions might be getting started. Like we're trying to start a criminal investigation into these forged documents at the district attorneys at the state level, because obviously we can't get it done at the national level at this point. So that was 22 months that you were able to postpone or stave off an auction date because of it took that long for the Secretary of State to come back with a decision.
No, they actually decided to sell the house in September of 2012. But now the notary complaint by itself, if you go into court, I will tell you, when you have the time while you're staving off stuff, that's not the time to sit back and watch football games or watch TV or whatever you're doing. That's the time that you need to study. I've been studying this thing for like 4 years, and law is not an easy thing to do. And when you're standing in front of a judge and you're the homeowner and you don't know much about it, you better sound semi like you know what you're talking about. Otherwise, they're just going to toss you because they prefer not to have pro-pers in there that don't know what they're talking about.
Right.
Don't ever say you want the free and clear house. Don't ever say that there was fraud or a criminal act in court. You say those things, you're pretty much done right there on the spot. You need to sound intelligent. You need to look semi-professional, and you need to conduct yourself in a professional business manner. And I know it's hard to detach yourself from the home, but you have to go in there with the attitude that I'm here to defend my home. I've got the law on my side, but sometimes that doesn't matter.
Right.
And just the truth is sometimes the last thing that matters in court.
And that's just such an unfortunate truism that people are discovering now. So so to just make sure I'm sort of rewording what I think I heard you say, you filed the notary complaint that helped postpone the auction on that property for a while. But they ended up taking it and selling it anyway, even with an outstanding complaint. And then you got the decision by the Secretary of State, which basically said that was a false notarization?
No. They can't really say it was a false notarization. They just revoked her commission based on what I had written. And let's back up just a second.
Okay.
They did sell the house. Now, I was in court yesterday morning at 8:30. And I did have the notary complaint by itself doesn't carry a whole lot of weight. Because it's like, yeah, you complained about the notary, so what?
Right.
What it comes back to is, yeah, guys, look, in April of 2011, I complained about the notary, and guess what? I now have the notary's commission revoked.
Right. Okay.
Now, that doesn't mean anything in 2013 about a substitution of trustee that was filed in 2009. Although, what you have to keep in mind is, Judge, everything I did in this complaint is based on the substitution of trustee that was filed in 2009.
Well, exactly. So why are you saying it doesn't really help in court?
But this is where it helps. What doesn't help? The notary complaint by itself doesn't help. What you have to realize is, here's the question that you're going to get asked: is it retroactive? That's the question you're going to get asked. Is the decision retroactive? Well, no, the decision's not retroactive. The decision's based from February 1st on. How does that help me based on something in 2009? That's where you have to understand what you're doing. To help me in 2009, a decision in 2013, number one is I got to show what the issues were in 2009.
Right, like false signing or something like that?
Yeah. What I've done is I've gone to, number one is, wherever the notary is, go to the county clerk's office. This was brought to me Randy. He said, look, go to the clerk's office and get the notary's oath.
Okay.
The notary's oath has their official signature on it.
That's correct.
Signature has to look like that on all documents. Well, I've got that. I also went to the county recorder's office. From 1995 to 2005, I have various documents that have her signature on that were recorded in the county. I've got all those. I got certified and put them into court. I now have a decision from 2013 that has her signature on it. They all look the same. It's beautiful penmanship. You can tell she wasn't from out here because it's beautiful penmanship. She's probably brought up back east somewhere.
Right.
And on my substitution of trustee, I have a series of 5 circles.
Okay, so I'm showing on the screen right now, not hers official signature, but what you get from the Secretary of State when you send in for the notary signature on the oath. And for example, this is a signature from E. Tamez. So what you're talking about, Rob, is that you got her original signature on her notary oath, and that does not match the substitution of trustee you've been talking about.
Correct. And let's clarify, it's a certified copy. I didn't get the original, I got a certified copy.
Right. Everybody gets certified copies. That's right.
Yeah, you can get a certified copy out from the county clerk's office. Wherever the notary is working in that county, you can get a copy of what you have on the screen right there.
Oh, that's great.
And always get it certified because that's the only way the court will recognize a certified copy.
Exactly.
It's a blank piece of paper. It's just not certified.
Right. But again, certification, like with the Secretary of State in California, is like $6. So you send them a check for $6, they will send you back a certified copy. And for those of you who have not ever gotten a certified copy, I've now seen them, and they just have a stamp on the back saying that they're certified. So the front still looks the same, but it's the stamp on the back that makes it official. And so now what are you going to do with that, Rob? Now that you've got her official signature and it does not match what's on the trustee substitution, do you think that will carry weight?
Yeah, what I'm doing is I am going to, yesterday I was in front of the judge, and he pretty much said, there's not a whole lot I can do based on the cause of action that I had before him at that moment. And this is where, when you're in court, pay attention to what the judge says. He guided me, and he gave me direction without giving me counsel.
Well, that's the most positive thing I've heard in a long time about a judge.
Well, yeah, he was asking. He goes, "Sir, is there anybody else you'd like to bring into this?"
All those other people.
Judge, he goes, I know we don't have Wells Fargo here on the current complaint. Is there anybody else you'd like to bring in? Okay. Do you happen to have maybe a different cause of action that could work?
Like, what would it be?
Yeah, he's like, what else are you thinking about? Well, I was like, stop. What did he just say? What did he just ask me?
Exactly.
Come up with something else really quick. So this is where, when you're in front of a judge, this is what you need to understand a lot of stuff. And I don't know if John talked about it yesterday. What I would highly recommend everybody have is a copy of Black's Law Dictionary. Okay. Go on eBay and pick them up for like $12 to $20. Get that. You're going to need that. The definitions in law are a lot different than they are in Webster's.
Yes. Yes.
And if you don't know them, you will get crushed.
Right. Because you'll be making wrong assumptions of what that word means.
Correct. I mean, you don't ever say you understand something. The Black's Law Dictionary says, if you ever walk in there and it says, sir, do you understand something? And you're there for a real estate thing, you read the definition, it says you understand they're taking your house. Literally, that's what it says.
Oh, my goodness.
It was like, I understand they're taking my house. Oh, okay, sure. Yeah, I understand that, Judge. So, boom, you lose.
My goodness.
You never understand anything in court if you're not an attorney. If you're a layman, you never understand anything. Uneducated in law, so why would you say yes?
I'm sorry for laughing. It's like, this is just insane. Okay. Advice well taken. Come on, everybody, let's listen up. And my goal, and I know Rob already knows this, and that is we need to get resolution. We need to stop these foreclosure mills from even filing these documents, and we're not the owners are not going to be able to go to court. Now maybe Rob's going to come up with something, because he told me something he's going to share here in a minute. But my goal is to get the correct people doing the fighting for the owners, and that would be the investigators of the Department of Justice, and to actually take this to the correct level and say, you know something, all this stuff is actually fraud and forgery on the face of it. False notarizations, these are false foreclosures. Anyway, go ahead, Rob. Tell us, so have you come up with a complaint yet that you're going to...
Yeah, what I'm going to do is I'm going to refile.
Okay.
The judge, this is where the first time I filed in August of 2012, I was denied the opportunity to amend my complaint in November. And this is where I'm going to tell you, if you're the homeowner, understand something, this is your home. If you go in there, you're there for one reason. Now, I have to be nice about this, because John and I have talked a lot, and I tend to phrase things like John does, and I want to make sure that I got to clean it up sometimes. My view is this: I'm here to cut their throat and step on their chest and watch them bleed out.
Yeah, I totally understand.
John says it a little differently, but
yes.
What you have to realize is that's your home.
Yes.
You've either raised your family in it, you have paid money for it, you have worked hard for it, you've upgraded it, you've done things that's your home.
Exactly.
And when people say this is a fight, they are not kidding.
Yes.
And this is a fight of attrition. You have to understand that. You may get to the point that you either run out of money,
right,
or you just flat out get tired of it.
Yeah.
Now, it's your home. What is it worth to you?
Right.
It is not worth a marriage. It is not worth your kids leaving you. Not worth that. It is just a piece of lumber.
Right.
Okay, so let's keep that in mind. This is not you have to die for.
Right. Right.
Keep that in mind when you're doing this. What I would recommend, though, is if you're going to go into this fight, I don't know if you always watch the movies of the 300 about the Spartans and stuff. My opinion is no retreat, no surrender. I don't, I've got 3 of these things that I'm dealing with right now, and I'm battling them, and I really don't care. No retreat, no surrender.
Right.
I will not give up.
Right.
What I recommend to people is study the law.
Right.
Study what you got to study. This is not something you were taught. It is something that they're hiding from you. And understand what you read in law may not be the case law that they're going by. Because case law says that it's an irregularity when you have a document that wasn't signed by the notary.
Irregularity?
It's called an irregularity.
Okay.
That's what the term is in law. That means, Judge, here's the thing. If you go to Black's Law Dictionary and you read the definition of irregularity, it says that irregularity is case specific.
Okay.
Within a specific case, this is irregular. Well, I filed stuff on Monday for a hearing I had on Wednesday, and I pointed that out to the judge. The judge, that's an irregularity. I filed stuff late. What this substitution of trustee is, this was filed 3.5 years prior to this case.
Right.
And it's a false and forged document. That's unjust enrichment through a criminal act.
Exactly.
Okay? And this is where you have to understand what they're talking about. And also, what they tried to slide by was in fraud, it's California Civil Code 338. They're going to come back to you and say, well, you know what? It's based on the fact that it was filed into the county. That's when discovery happened, and so you should know that. Well, wait a second. See, take your real estate. When you file something into the county, isn't that constructive notice? That just gives the people public notice, right?
Right.
That's not discovery. I discovered the different signature in February of 2011 when a friend of mine sent me a letter that was personally signed by the notary years from the date of discovery, not constructive notice. This is where you need to understand as a homeowner what's going on. If you go down and you pull that document, you get it certified, and you start digging, you got 3 years on for fraud. Now you'll have to check for negligence. You'll have to check for other causes of action. They all have different statute of limitations. And this is what you have to start understanding. If you want a good movie to reference, I was talking to probably one of the best class action law attorneys in the country when we were actually contemplating taking this to a class action lawsuit. And he said, he says, first-year law students, the very first movie they should watch, and it sounded, I looked at this guy like he was an idiot, but he's really good. He says, My Cousin Vinny.
Right.
He says, the entire movie is built on procedure in law. You want to understand law, watch that movie, because it's built on procedure. If you get something on time, and it's semi-good, you're going to keep your case going. If you're late, if it's sloppy, you're done.
Right.
Now, as far as the notary complaint is concerned, like I said, I wrote the book. I wrote a guide based on John Stewart's teachings, and it's at notarycomplaint.com. What I am looking to do now, based on the fact that I know what has happened and I know what's going on.
Yes.
I live down in California. I've got 5 counties that are close to me. I live in San Bernardino County. I got Riverside, Orange County, LA County, and San Diego County. What I've already done is I've gone over to Riverside County. If you have time, if you're retired, or if you work at night and you have during the day, check with the county, find out when they're open.
Right.
A friend of mine and I went over to Riverside County. I know the time frame I'm looking at for the false and forged signatures. Mine happened in February of 2009. So I took 1 week in December of 2008, and I took 2 weeks in February of 2009. Punched in substitution of trustee for the county that I was in. And at that time it was Riverside. Then I went to San Bernardino. In a 3-week time frame, I found 45, probably like 65 to 70, some of them were questionable, but minimum 50 legitimately forged documents.
Now, how do you know that they were forged? What was that? How did you decide that or determine that?
Don't forget, I know what the signature is supposed to look like.
Oh, you're talking about strictly that notary?
Got one notary in a 3-week time frame. I got 45 legitimately false and forged signed documents. 3-week time frame. My goal now is to get to roughly about 100 to 150 false and forged documents per county. And I'm going to go to all 5 counties around me.
And you just took that one notary. That's what you're doing, is taking that notary specifically and then going into the recorder's office, typing in, because it's all computerized, typing in the search criteria of these couple of weeks. And then do you just look at the trustee substitutions and find which ones that person notarized?
Yeah, what I do is I look under quality loan service. Yeah, in Riverside, you just type in one word. So I just type in quality. Substitution of trustee from this time frame to this time frame.
Oh, from the company that ordered it, got it. The foreclosure trust email. Okay.
Yeah, and what has happened is, as you're going through these, I'm obviously specifically looking for quality. So every time quality comes up, I'm going to look at that document because it doesn't say who signed it.
Exactly.
I'm noticing other signatures that are false and forged, that have variations in them.
Of course.
For other trustees at the same company. Other notaries at the same company.
Right. Of course.
But I'm specific to one because the notary complaint on that one, got the decision on that one. Now, if you're going to do it, I wouldn't recommend waiting the 22 months.
Right. Right.
Go get the notary's oath, and if they happen to be in that county or you're in that county, all I did was run a search for the notary's name. And it popped up with a quitclaim deed, it popped up with a power of attorney, and it popped up with her bond.
Right.
I got the other signatures. They're all matching, all the way from 1995 to 2013. Obviously, there's slight variations because of age and everything like that.
Right.
But they all look extremely similar. They all have the same characteristics.
And they're all different from the official signature.
No, they're all the same.
Oh, they're all the same.
They're all the same. The substitution of trustee, on the substitution of trustee, that signature is different.
Right.
It's a series of 5 circles.
Right.
That's where now I have a lot. I've got a huge amount of evidence, and I've got all these signatures perfect for the signature of the notary. I now have this false and forged document. So now what do? There's a couple things you can do. Number one is you can go out and try to find yourself a handwriting expert. Okay. You'll get $500 to $1,000, $1,500 sometimes. And if they got to show up in court, they're going to charge you. What happens is in court, at least this is what I'm doing on this particular case. Normally I demand a jury trial. This case I did not demand a jury trial. Opposing counsel has not demanded a jury trial. What I'm going to do is I'm going to go in and ask the judge. The judge, to the best of my knowledge, ask counsel, do they want a jury trial? I didn't ask for one. And if they say no, according to now, let's be very clear. None of this is legal advice. I'm only telling you what I've done.
Right. Exactly. Oh, exactly.
According to California Code of Evidence, I think it's called 1417, the trier of fact is allowed to determine the genuineness of a signature.
Who is allowed?
The trier of fact, F-A-C-T. Understand, that's 2 parties in court. When you go to court, the judge is the trier of law. He knows the law, or she knows the law. The jury is the trier of fact. So you've got 2 parties. You've got the trier of law and the trier of fact.
Right.
Well, if you don't demand a jury trial, who becomes the trier of fact?
The judge, I'm assuming.
Okay, gee, judge, according to the evidence code, the trier of fact can determine the genuineness of the signature. Since you're the trier of fact, what's your determination? Understanding, judge, that you don't, here's the term I was told by this class action attorney, understanding we don't want to create any judicial prejudice. Basically what that means is, if you screw up, I'm going to appeal it. That was the code I was given. We don't want to create any judicial prejudice, Judge. And he said, and the guy looked at me and goes, that's code for I will appeal us.
I tell you, you got to learn how to have leverage. It's all about leverage. That's what I'm working so hard for, to get owners some leverage in this.
Well, okay. I mean, it was hilarious because I said that yesterday. The judge looks at me like, holy shit, you know that.
You know my code words.
When, if you ever want to serve somebody and you ever want to really just like mess with them, have a process server serve it. Because you can have a friend of yours serve it, that's one thing, but a process server is an officer of the court. If they don't answer, that's what you just done. Wait a minute, why are you not answering the court?
Exactly.
You might want to think now. Obviously, you can't do that with everything because it can range anywhere from $40 to $75 depending on the process serving.
Right.
But if it's important, anytime you file a complaint, you're going to process serving.
Right.
But if you really want to mess with somebody, have a process server serve it, because now you can take them to court and say, well, Judge, look, an officer of your court served them and they didn't answer. Now that can really mess with somebody.
Now, Rob, just brief us. What kind of lawsuit did you file? And now we understand you're going to be shifting the complaint. So, what were you in? What started all this?
As far as the notary complaint is concerned, I filed a quiet title action.
Okay, quiet
title.
title.
And it got blown up. I tried to do it. I did it incorrectly. And I tried to do cancellation of insurance because I knew, you and I were discussing, off the air that the whole thing is based on credit and it's based on your signature and stuff. Well,
right.
I made the mistake of trying to explain that to the judge, who was like getting ready to retire. He didn't care. Didn't want to hear it.
I know.
So
he
denied it without prejudice, or denied it with prejudice. I wasn't allowed to amend. But the new guy is like really, I'm not going to say he's different
Yeah, I'm familiar with some of that. Yeah.
Yeah, some people know that, some people don't. So
Yeah.
I just want to get it out there so everybody understands that. I was ready to dismiss this entire case based on the fact that I couldn't find the notary. And I was talking to a friend of mine on my way to court to dismiss everybody. And he said, no, don't do that. Do this.
Right.
Now you have to understand, I'm wearing basically jeans and a t-shirt.
Right.
You don't go into court like that.
Right. 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 Get a suit.
I ended up in front of the judge, so I was just going to walk in, dismiss him, turn around, and walk out. But, I ended up in front of the judge, standing in front of the judge, jeans, t-shirt, hadn't changed in 2 days.
Oh, boy.
Oh, yeah. Don't I look like I know what I'm doing.
I just came off the street, Judge. Okay, so now what you're doing is what? So are you in another quiet title action? Is that what you're doing right now?
No, what I'm going to do is I'm going to shift it. The whole objective now is to get the substitution of trustee blown up.
Okay, blow up the trustee substitution. So how are you going to do that?
I'm going to file the notary complaint. I'm going to be filing all the recorded documents from the San Bernardino County Recorder's Office, San Diego County Recorder's Office. I'm going to file her oath that has all of her legitimate signatures on it.
Right.
I'm going to file the decision from the California Secretary of State, and I'm going to use the Code of Evidence. I mean, if I can afford to have a writing expert do it between now and then, I will. I have 30 days to amend the complaint.
Okay.
I'm going to file it under negligence.
Okay.
And that it's like, because now, see, here's part of what happened. July of 2011, I faxed my notary complaint to Quality Loan Service.
That's right. You've been faxing them.
Mm-hmm. Letting them know, look, you might want to wait. Well, now, you can put the notary complaint in saying, Judge, look, they were noticed in July of 2011.
Exactly.
Notice becomes huge. I don't care what, they just made the mistake of, foreclosing on another one of my houses.
Right.
With a different one having the exact same factors in litigation, and they know it. So now I need to notice them saying, look, here's the notice. If you want to continue this, that's fine. All it means is damages are going to be bigger.
Okay, so what I'm hearing, and I want to make this point clear and verify with you, Rob, when you got the notary complaint, you kept noticing by faxing to the foreclosure trustee, you kept faxing them a few days before the scheduled auction to get a postponement. They postponed until finally they didn't do it anymore. They just foreclosed. So now you can take that effort that you put into it to faxing them and letting them know, hey, wait, you don't want to foreclose right now because I've got this notary complaint outstanding. Now in your lawsuit, you can say, look, I told them all about it. And they went ahead and did this instead anyway. Correct?
Correct. And also, I know you said a few days. What you want to make sure is you're talking, give them about 2 weeks. Remember, you're talking some big company that they got to hold the beneficiary and all this other garbage.
Right.
They have to run through the motions. Don't fax it today for a sale on Monday. Don't do that.
Exactly.
Give them at least 10 business days, and you should be good.
Right, and that's what I tell people. They'll often find me like at the last minute, and their auction is like tomorrow, and they'll find me today, and they'll say, what should I do? And I'm going, well, okay, right this second, you can try an OCC complaint and try to get it to the foreclosure trustee in time to stop it, but, sometimes it's just too late, just like you said. They did.
I know that'll.
Yeah.
The only thing I know that'll do it that fast is a bankruptcy.
Yeah.
Filing a bankruptcy. That's the only thing I know that'll do it that fast.
And even sometimes I've heard that doesn't work. I mean, anyway, you give them some time. It's always highly recommended, just like Rob's been telling us. Don't just sit on your, around and watching TV when you're trying to fight this battle. Keep really on top of it and keep forcing the issue. Now you're going to be filing a complaint to prove or get the trustee substitution removed, or what do you think is going to happen?
What I want to happen, or what I think is going to happen?
Well, John said yesterday what we want and what happens.
When they're showing how the substitution trustee is a void document.
Right.
Understand something. They came back trying to say that it's a voidable document. It's two different documents. That It means the parties that are involved in the document, the contract, whatever it is, can agree that amongst themselves that it's a voidable document and that we want to redo it.
Right, it can be redone. Right.
A void document is just that. It's void on its face.
Right. And
to the best of my knowledge, in the state of California, this is part of what my complaint's going to read, is that the elements of a substitution of trustee are that you have to have an authorized party from the, in this case it was MERS, and then you have to have, a valid signature from the notary.
And Rob, I've already found case law that supports if the trustee substitution is void, everything is void after that. I'm going to send that to you. I've quoted those cases for California on the suspicious signatures document that we're developing. I'm almost ready to start showing on the air how that works, how I've sent it out to people that are desperate. This is as good as we've got right now. But anyway, I'll send that to you, so maybe some of that case law could be helpful for you.
Yeah, that's something because the guy that's helping me out, I mean, he's really good. Without him, I wouldn't be where I'm at.
Yeah.
He has, I give him my ideas, and I will write what it is, and I send it to him, and he cleans it up and makes it court ready.
Right. Right. Is he a paralegal or just somebody helping you do that?
He could be a paralegal. He just doesn't want to.
Yeah.
He doesn't want to tell people that.
Yeah.
He's been studying law for a long time.
Yeah. There's a whole bunch of people.
He's a young guy.
Yeah.
But he was put into a position where he had to study the law.
Yep.
And he never bothered to take the test or anything.
Right.
He's had people telling him, dude, you need to be an attorney. He goes, why would I want to limit myself and be restricted by a bar card?
I see this all over. The people that are brilliant, they have a mind for this. They are stepping up. They're helping people in court that are doing pro per, and others are actually, just like this guy helping Rob, they're cleaning up the document so that it's court ready. They probably know more than most attorneys, and I'm thrilled because it's when the people rise up across the country helping each other out in our legal system that we can really start to affect some changes. And just because you're a licensee, whether you're an attorney or whether you're an agent or a broker, doesn't mean you really know much. And that's what a lot of people don't understand, that just because they've passed an exam doesn't necessarily mean that, one, they're honest, two, they have integrity, three, they're really going to fight for right, and four, that they really know something, or that they will research in a manner that those that really have the motivation to find the answers will. So that's what Rob is doing. He's doing the research, going to people that'll help him, and so when are you filing the case, Rob? Tell us. Let's finish this up. Tell us where you're at right now, and what are you going to do with those? You said you'd found all these other documents. Are you going to include those, or what?
No, I can't bring those in because they're not specific to this case.
Okay.
What I plan on doing with those, let me clean this up real quick, just so that everybody understands. Attorneys understand why they do things. I've been on several shows, and I've challenged any attorney listening to tell me I'm wrong. They get paid for billable hours.
Of course.
Don't ever forget that.
Of
For
course.
billable hours. They don't get paid to save your house.
I'll tell you a quick little story, but I have an attorney client. Well, he is an attorney, but the fact is he got hired by a big firm, and somebody came in with a complaint, and he says, "Oh, this is easy, I can fix this," and he fixed it, like in 2 hours, and they fired him because they said, "Oh my goodness, you're supposed to stretch that out for 6 months." He said, "Well, I can't do that." Well, there you go. Anyway, go ahead.
Yeah, he had a thing most attorneys don't have called ethics. What I plan on doing is I'm going to file within the next 30 days.
Okay.
And I've already started writing it. My friend's going to help me clean it up, and we're going to get probably 2 or 3 causes of action. What you'll find is most homeowners, they want to give you a laundry list of 20 different things. Not enough. So remember, banks see this stuff all the time.
Right.
See these, to them, it's a template. Pick 1 or 2 and just be a laser beam and go after it.
Right. I've heard that before.
Don't try to, because the more you do, the more tired you get, and the more convoluted your facts get.
Well, and the more opportunity they have to come back at you to get a demur or something. I've heard this before from very good authority. You know, just like Rob said, get 2 or 3, that's it. Laser focus. Just remember that even the judges are people. And when they see, 50 causes of action, it's like, oh my goodness. But 2 or 3, they can take time to read that and look at it. Go ahead, Rob.
That's it. They will. They'll look at 2 or 3,
Yeah.
especially if it's written by a pro per and they see 25 causes of action. If they start, denying you, they're just going to run down the list.
Right. Right.
They just don't want to deal with it.
Right.
So, always keep that in mind. And another thing, if you go into a state court, do not, under any circumstances, bring in federal causes of action.
Right.
In state courts, stay with state issues. TILA, RESPA, those are all federal issues.
Right.
For court.
Right.
Entitled, negligence, intentional infliction of emotional distress, those can be all state issues.
Right.
Stay there. As far as, like I said, that's what we plan on doing to clean it up. Let's see, I already talked about what I'm planning on doing. With the documents that I found in the Riverside and San Bernardino County so far, I still have LA, Orange County, and San Diego to go to. What I'm doing right now is I'm writing a letter that a friend of mine is going to help me edit and try to, we're going to see what we can do about turning it into I don't know if we can turn it into a criminal complaint, but we can sure get it ready. I'm going to get all these documents together. I'm picking up one document from each county to show that, look, this is legit. I'm going to start getting this certified.
Right.
And I'm going to have a list of like 45 to 100 other document numbers.
Right.
Look, every single one of these documents is roughly the same.
Right.
It doesn't match this.
Right.
What I plan on doing with those is I'm going to put together a letter and a packet. It's going to go to the San Diego, Riverside, Orange County, LA County, and San Bernardino County district attorneys. It's going to go to the county recorder's offices. It's going to go to the governor. It's going to go to the attorney general.
Right.
In the information I got back from the notary, it was sent to, allegedly, she signed stuff for Washington, Nevada, and Arizona also.
Right.
So it's going to go to their governor, their attorney general, and then because it crossed state lines, it's going to go to the Department of Justice, and it's going to go to the FBI. We're going to end up with about 30 different government agencies that this thing's going to.
Right.
And on top of that, it's going to ABC, NBC, CNN, CBS, Wall Street Journal, Newsweek, and it's going to go to all of those people. It's going to go to roughly about 50 different people.
Exactly. And this is basically the heart of what I've been pushing, is that individuals to get their own documents and get the original signatures, and if they're different, to file these complaints, and then just basically let's plaster the planet, because the facts are these are the building blocks of fraud. This is what they did. They faked every foreclosure document, and that is the truth. That is the point, and the people can prove this. So, Rob, we so thank you for sharing with us, and for writing the book, and for going into court, and for doing this work and effort. Please keep us updated. And again, I've already asked you, please send me a copy so that I can forward that to the contacts that I'm already starting to work with now, that are starting to show some interest in criminal complaints. And it's the criminal element. We've got to snag these people, and we've got to make them pay for this fraud game that they've perpetrated on the country for their own personal benefit, and to steal the land, because it is, the whole point is to take the land. They want the land. And that's why it's so important. I know Rob says it's not worth the family, and it isn't. You got to have your life. But if you have any ability and effort to hang in there and fight to keep the land, please do that. The more land the people keep, the more we keep our freedoms. As landowners, we have rights and abilities that you do not have as tenants and renters. It's a different mindset. And so the people in this country need to keep land ownership available and alive. Thanks, Rob. Thanks for sharing with us. We look forward to an update tomorrow. This is CJ signing off now for Weekdays Live, and we'll see you tomorrow. Thanks for watching.